Thank you, Chairman, and welcome to both nominees. There is a distinction that I would like to try to elucidate that I hope you'll both agree with. Let me ask first whether you agree that we ought not base our decisions to vote for or against your confirmation on your religious beliefs.
You're asking me if I agree with that, Senator
Yes.
Whitehouse. Yeah, that's. I agree with that fully.
I agree, Senator.
And I agree as well. Now let me ask the corollary, which I think makes the distinction. Do you agree that we have a responsibility here in the Senate to assure that litigants appearing before you as judges won't have your religious beliefs imposed on their case?
Senator, I think that if a judge were doing that, it would be totally improper.
I agree. My oath is to the Constitution. In the case of it being a Minnesota Supreme Court justice, it's to the Constitution of the state of Minnesota as well. It is not to my own religious beliefs.
And I think that is a key distinction for this committee. It is important for us to, I believe, ask questions that can clarify that when litigants come before you, you won't impose your religious beliefs on their case. But your own religious beliefs are your own business. Is that a fair statement of where we should be falling on that distinction?
I agree, Senator.
Senator, I agree. I think that there's a religious test clause in the Constitution. I think there's an establishment clause in the Constitution.
It's pretty clear.
There shall be no establishment of religion, Senator.
Let me ask you, is there discretion on the part of the judge extant in the business of judging?
I didn't understand the end of that question.
Is there discretion on the part of the judge as a necessary part of the business of judging?
It depends on the case. Yes, typically there is discretion. In different cases, that discretion is going to take different forms.
Yep. Often guided by the law, but often with considerable discretion remaining to the judge, correct?
In my view, it ought to be as limited as possible.
And that is
yes.
why, to switch to Judge Stras, that is why, among other things, we have an abuse of discretion standard. It wouldn't make sense to have an abuse of discretion standard if there weren't discretion, would it?
That's absolutely right. I mean, in reviewing these cases of Minnesota Supreme Court justice, we've had a number of cases involving discretionary decisions by district courts. And
abuse of discretion is a pretty generous standard to the judge, allowing considerable play for the exercise of the judge's discretion before it gets to the level of abuse, correct?
It is. It's deferential.
So I gather that means that, first of all, I understand that you both know who Judge Cardozo is and Judge Frankfurter, right?
Yes.
Yes.
Obviously. Judge Cardozo, in his seminal work, The Nature of Judicial Process, first recognized that many cases are squarely controlled by precedent, but went on to say that it's when the references in the index fail, when there is no decisive precedent, that the serious business of the judge begins. And similarly, Justice Frankfurter reacted to what he called this assumption that judges only find the law and don't make it as follows. He said, by covering up the lawmaking function of judges, we miseducate the people and fail to bring out into the open the real responsibility of judges for what they do. Do you believe that Justice Frankfurter and Judge Cardozo were speaking accurately about those circumstances?
For me, Senator, yes. I think Justice Cardozo in particular, and I've read that book, he exemplified that when he was on the New York Court of Appeals. In particular, even more so than on the U.S. Supreme Court, because he was dealing there with common law issues.
Yeah.
And he was developing the law incrementally as a common law judge, and that's what he became known for. So I think he's accurate there.
And I've sat on a court of last resort for 7 years, and many of the cases we get, the discretionary review, are open questions. They're questions of first impression, and you have to look at the body of law and exercise your judgment as to what the correct answer is, and that's what I've tried to do.
So it would be fair and appropriate for us to assure that future litigants won't be mistreated in your courtroom by being subjected to religious or other personal beliefs in those areas where uncertainty of the law or discretion of the judge allow for the play of your own convictions and conscience.
Absolutely correct, yes.
Senator, I think that's a basic component of the judicial oath that I would be required to take if I were confirmed. That I would treat people equally, not respecting persons, not respecting rich and poor. But frankly, Senator, as a lawyer, I think it would be unbecoming of an officer of the court to treat one's opponents that way as well. The duty of a judge is even higher than that.
Yeah. Well, Mr. Chairman, thank you very much. I wanted to bring out those questions with these nominees, and I may do it again with others, because there's been considerable, I think, uninformed commentary when our side asks questions about religious beliefs of a nominee that we're trespassing into the area of some kind of test in which we're not going to vote for them if they have the wrong religious beliefs, when I think as these nominees recognize there is room for discretion, there is uncertainty in the law, and litigants do have a right to a judge who won't impose religious beliefs in the courtroom on them when those areas of uncertainty or discretion arise. And I just want to make sure that point is clear in this committee, because I don't think it's an honest or factual discussion to presume otherwise. Thank you, Chairman.
Thank you.